Well, good afternoon, everybody. Keep this as quick as possible. Saturday afternoon, my time, Saturday evening, Australia time. Very fortunate that Tracy Keogh has agreed to join me to do another live chat looking at Brendan Dassey. I'm just going to carry on with this series of articles that look looking at the 7th Circus en banc decision. And as you know, the last thing we looked at, pretty bizarre, was the hang on a second, let me just sort this out. Yeah, there we go. Sorry about that. So yeah, we're going to have a chat with Tracy Keogh on Saturday. That's 12:30, just after midday UK time, which will be 9:30 in Australia. Looking forward to that chat with Tracy, a huge supporter of Brendan. As I say, we've been looking at the 7th Circus decision. The majority opinion was written by Hamilton. The last thing we did was just to recap. We looked at a couple of things from the 7th Circus decision. And I wanted to well, let's start at the beginning. Let's do this first of all. Let's screen share so I can show you this thing here. That, to me, this just strikes as the fact that we know that the Brendan Dassey situation is hugely political, and for me, this just speaks volumes about the cowardice of these supposed learned judges at the 7th Circus. You know, this was Seth Waxman. I have never had a case that has troubled me more than Brendan Dassey's case, that has kept me awake at night, that makes me anxious and sad. And that is because I know that Brendan Dassey is innocent. But I also know that no judge, not the state trial judge, obviously that was Jerome Fox, not the State Court of Appeals, that was Paul Riley and Neuberg, and one other whose name escapes me, not the federal district judge. Well, obviously, yeah, we know that that was a very good decision by Duffin. Not any of the judges on the 7th Circus. Well, we know 3 of them were dissenting, but there were 4 cowards. Not a single justice sitting on the Supreme Court think otherwise. So you know, it just shows what a political hot potato this is, and the fact that the judges are just happy to wash their hands. So we were looking at the 7th Circus decision, weren't we? Written by Hamilton. And this really did twist my melons, so to speak, because he wrote here, where the record shows that the state courts have strayed from clearly established federal law, we can and do grant relief. Notice the word we, because of the 7th Circus. But I wanted to find out, you know, when did Hamilton actually, did he ever grant anybody habeas relief? Or was he just a yes man for any state that had a problem? As I say, he quotes the example of Richardson versus Griffin. But guess what? Richardson versus Griffin, he wasn't involved in that. It was before Wood, Ripple and Rovner. Wood and Rovner, of course, being 2 judges that voted in favour of Brendan. Here we've got a decision in 2017. Sorry, Richardson and Griffin. Let's find Richardson, Griffin, Jones, Callaway, 26. So here we go, 2016. Before Easterbrook, Rovner and Sykes. Nothing to do with Hamilton there. What about McManus? McManus versus Neal that he quotes from 2015. Again, nothing at all to do with Hamilton. Is he just being shy? Do you think there were cases that he granted a writ of habeas corpus and he just didn't want to, to show off that he granted all these? No, I don't think so. I think you've got to go back to 2013. Finally, Flom, Wood and Hamilton, they granted a writ of habeas corpus. And I thought what might be interesting would be if we actually looked at what that case actually involved. How bad does a case need to be before they grant a writ of habeas corpus? As I say, bearing in mind that the case of Shaw versus Wilson back in 2013 was not the heater that Brendan Dassey's case was. It is very disturbing that the case had to go as far as the Seventh Circuit before it was resolved. Let's have a look at it now. We might not go through the whole case, but just so that you get an idea of this case, where, as I say, this isn't Hamilton that writes this opinion, by the way. This isn't Hamilton. I think this is Judge Wood that actually wrote that he be given the writ of habeas corpus. But let's have a look and see what it says here. So this is Troy Shaw versus Bill Wilson, decided July 24th. Well, that was just coming up for 7 years ago. And the case came before, I'll just do this, see if I can get it to go a bit. Yeah, that's a bit better. This case came before Judge Flom, Wood and Hamilton. The circuit judges, Michael Orsbuck, Bloomington, Indiana, for petitioner, appellant. James Blaine Martin, Office of the Attorney General, Indianapolis, for respondent, appellee. Okay, here's the case. Troy Shaw and two other men were arrested and charged by the state of Indiana for an information with aggravated battery after Brett King was beaten to death outside a motel in Fort Wayne. Shaw denied participating in King's beating, but the other two men, in exchange for prison sentences of under 3 years, agreed to plead guilty to voluntary manslaughter and to testify against Shaw. The state then moved to amend the information to elevate the charge against Shaw from aggravated battery to murder. The trial court granted the state's motion over Shaw's objection that the murder charge was barred, a procedural bar. Where have we come across them before? Was barred by an Indiana statute that limits the time for amending charging documents. Shaw was convicted after a jury trial and sentenced to 60 years in prison. As we come to it later on, they were barred, in fact, by upping the charge. It had to be done within either 30 or 60 days. They did about 17 months later. Anyway, let's carry on then. I'll look a bit more detail at the case. On direct appeal, Shaw's new lawyer abandoned trial counsel's contention that the information was amended too late, and instead pressed a futile claim that the evidence against Shaw was insufficient to support his conviction. Not surprisingly. Why not surprisingly? I don't know. The appellate court was unpersuaded. Oh, well, yes. Appellate courts, they very rarely, do they ever if it's the same judge, change their opinion. Appellate counsel dropped the case at that point and did not file a petition to transfer with the Supreme Court of Indiana. Shaw persisted with a petition for post-conviction relief in the Indiana courts, but that too failed all the way up the line to the state Supreme Court. Shaw then turned to the federal court with a petition under 2254. The famous 2254. There he argued again that his appellate lawyer's decision to forego challenging the validity of the amended information in favor of a frivolous sufficiency challenge constituted ineffective assistance of counsel in violation of the Sixth Amendment. So we're dealing with an ineffective assistance of counsel. The district court denied relief, but we conclude, with full cognizance of the high bar that such a case must clear, that the Indiana Appellate Court's decision to the contrary is an unreasonable application of Strickland and the elaboration on Strickland of Smith versus Robbins. We therefore vacate the judgment of the district court and remand with instructions to issue a writ of habeas corpus unless the state of Indiana grants Shaw a new direct appeal in which he will have the opportunity to advance the argument that his appellate counsel should have raised. I say this is written by Wood. And I don't know about you, but I couldn't help thinking when you're listening to the Seventh Circuit en banc arguments, the hostility, well, not just in the arguments, but also the way they spoke, the way they spoke towards obviously Laura, some of them, very derogatory towards her, and then you get that such a split of opinions. You wonder, have they ever agreed on anything? Well, here we go. Here is a case in which Judge Wood and Judge Hamilton agreed. We don't know about Flom. He was one of the ones that decided he couldn't even face the prospect of trying to consider Brendan Dassey versus the state. Let's have a look at the actual details of the case. So, offence and trial. Shaw was 18 years old and had just finished high school at the time of the deadly attack that landed him in prison. Days earlier, he had been recruited to sell magazine subscriptions as part of a traveling sales team, and he arrived in Fort Wayne, Indiana, with the team on June the 5th, 2000. The trouble began when his boss, Eric Wernicki, rented several motel rooms for the group, and in one of those rooms encountered and confronted Brett King, an uninvited stranger. King fled, but as he ran away from the motel, Wernicki yelled to his employers, "Get the horrible person." Two of them, Steve Johnson and Chris Starling, obliged, chasing King down and knocking him into a ditch. Several other team members then joined Johnson and Starling in punching and kicking King. He died in the ditch from multiple blows to his head. A little bit over the top, don't you think? Just a mob mentality just went way too far. The idea is to just arrest him, citizen's arrest, and say, what the hell were you doing in the motel room? The attackers had disbanded by the time police arrived, but Johnson, Shaw, and a third team member, Benjamin Brooks, were arrested and charged with aggravated battery. Shaw denied even being present during the fatal beating, but Johnson and Brooks admitted participating, and at some point they told authorities that Shaw had been the most aggressive of the attackers. The two negotiated sentences of 2.5 years in prison, 8 year sentences with 5.5 of those years suspended. in exchange for pleading guilty to involuntary manslaughter and agreeing to testify against Shaw. Pretty awful state of affairs, would you not agree? After Johnson and Brooks cut their incredibly lenient plea deal, the state moved to amend the information to charge Shaw with murder rather than aggravated battery. His trial lawyer objected on the basis of Indiana Code 353415 1982, a statute that had long limited prosecutors' discretion to amend pending charges. The version of the statute then in effect specified that an amendment of substance could be made up to 30 days before the omnibus date, defined by state law as a point in time from which various deadlines are established. And an amendment of mere form could be made even later, if not prejudicial. Because the precise language of the 1982 version of the state statute is important to Shaw's case, we set out the relevant portions here. B. The indictment or information may be amended in matters of substance or form, and the names of material witnesses may be added by the prosecutor attorney upon given written notice to the defendant at any time up to 1. 30 days if the defendant is charged with a felony, or 15 days if the defendant is charged only with one or more misdemeanors before the omnibus date. When the information or indictment is amended, it shall be signed by the prosecuting attorney. C. Upon motion of the prosecuting attorney, the court may, at any time before, during, or after the trial, permit an amendment to the indictment or information in respect to any defect, imperfection, or omission in form which does not prejudice the substantial rights of the defendant. And D. Before amendment of any indictment or information other than amendment as provided in subsection B of this section, the court shall give all parties adequate notice of the intended amendment and an opportunity to be heard. Upon permitting such amendment, the court shall, upon motion by the defendant, order any continuance of the proceedings which may be necessary to accord the defendant adequate opportunity to prepare his defense. The state statute. Although no Indiana appellate court ever had invalidated an amendment under the 1982 law, in 1998 in Hark versus Indiana, the Indiana Supreme Court held unequivocally that if an amendment was of substance or prejudicial to the defendant, even if of form, it was impermissible under the statute from 30 days before the omnibus date. Shaw's omnibus date was July 31st, 2000, and the amendment was not proposed until 17 months later. Wow. Nevertheless, despite the 3-year-old precedent in Hark, the trial court granted the state's motion. Gee whiz. Shaw's attorney then asked for a continuance to permit time to prepare a defense to the murder charge, and he was given 2 months. At trial, Johnson and Brooks both testified that Shaw had kicked King in the head repeatedly and viciously. In his defense, Shaw called an inmate who had shared a jail cell with Brooks. The inmate testified that he overheard Brooks on the telephone blaming his boss, Rosinski, for the fatal blows to King's head. Quote, according to media reports, Rosinski and Starling were not charged with a crime until after Shaw's conviction, at which point they were charged respectively with aided battery and assisting a criminal. Stalin pleaded guilty and was sentenced to serve 18 months in prison. Wozinski was convicted at trial and sentenced to 6 years, of which he was expected to serve under 3. And see this article by Sarah Eaton. Fifth salesman gets 6 years for role in motel slaying. Fort Wayne J. Gazette of 2003. Shaw testified as well, insisting that he had gone to sleep rather than follow the crowd to the ditch where King was killed. The jury believed Johnson and Brooks and found Shaw guilty of murder. A public defender, Gregory Miller, handled Shaw's appeal and settled on a single appellate argument. The prosecution's evidence was insufficient to support the jury's verdict. Miller filed a short brief in which he observed that there is conflicting testimony as to whether the defendant, Troy Shaw, was in the ditch where Brett King was murdered. This observation was both true and catastrophic for Shaw's appeal. It amounted to a confession that the appeal was doomed because Indiana courts, like federal courts, must resolve all evidentiary conflicts in the prosecution's favor, and they must reject a sufficiency challenge unless no reasonable trier of fact could have found the defendant guilty. See Jackson versus Indiana, 2010. Shaw's conviction was affirmed in a short opinion deferring to the juror's assessment of the witness's credibility. See Shaw versus Indiana. Okay. Fajardo, I presume, versus Indiana. Roughly 4 years after Shaw lost his direct appeal, the Indiana Supreme Court revisited the issue of untimely amendments of substance in Fajardo versus Indiana, 2007. The trial court in that case had allowed the prosecution to add a second count of child molestation to the information after it concluded that the amendment would not prejudice the defendant. Tellingly, the Indiana Supreme Court reversed and confirmed that it meant what it had said in Hark about the proper reading to be given to the statute. It had to be within 30 days. Citing Hark and declaring that the statute is clear, the court concluded that because the challenged amendment in this case sought to modify the original felony information in matters of substance, it was permissible only up to 30 days before the omnibus date, regardless of prejudice. As a result, the court vacated the defendant's second conviction. It's nice to see that some courts uphold on the basis of statutes being ignored. Obviously, one thinks of the handing back of the cremains to the holdback, completely contrary to state statute. I know that a lot of supporters feel that simple fact is one of the worst aspects of Steve's case, and that the District 2 of the Wisconsin Court of Appeals, which includes Paul Riley, will surely look at that and realize that you know, even on that fact alone, the handing back of the cremains, that is a direct contradiction, and a blatant disregard for state statute that Norm Garm himself wrote. Anyway, let's carry on. The state Supreme Court noted in Fajardo that for decades, Indiana law had strictly limited prosecutors' discretion to amend pending charges. Indeed, under the 1970s version of the statute, amendments of substance were prohibited entirely after arraignment. The court also observed that decisions applying the 1982 version of the statute had been inconsistent and conflicting. Appellate panels, it acknowledged, had disregarded the language of the statute. Yeah, this is good. Appellate panels acknowledged had disregarded the language of the statute even after Hark, and one of the Supreme Court's own post-Hark decisions, Brown versus State, was problematic because it conflated the issue of prejudice with the question of substance versus form. The amendment in Brown, however, was determined to be one of form rather than substance, and so the analysis, though confused, did not contradict Hark's pronouncement about substantive amendments. After Vallarta was decided, the Indiana legislature repudiated the decision by amending the statute to allow substantive amendments to charging documents at any time before trial, if not prejudicial. Okay, so state post-conviction proceedings. Getting back to Shaw here. After his conviction was upheld on direct appeal, Shaw filed a post-conviction petition in state court in which he asserted that his appellate lawyer's performance had been deficient and prejudicial in that he abandoned trial counsel's promising challenge to the validity of the amended information. Invoking the two-part analysis of Strickland versus Washington, Shaw argued that omitting the claim under section 3534.15 constituted deficient performance because that claim was significantly stronger than the sufficiency challenge that appellate counsel actually made. With respect to prejudice, Shaw contended that the abandoned claim likely would have succeeded if made, and his conviction, like the defendants in Vallarta, would have been vacated. However, the trial court rejected Shaw's petition, and he appealed to the Court of Appeals of Indiana. That court conceded that Attorney Miller possibly could have argued that the text of the state statute required the amendment to be dismissed, as was argued in Vallarta, though the court also stressed that case law was mostly against him. Oh, wow. Shaw versus Indiana. Some decisions of the state Supreme Court included dicta indicating an amendment of substance would be invalidated if it was untimely. The court explained, but no amendment actually had been invalidated under the 1982 version of the statute. Instead, the court continued, a long line of Indiana decisions had treated amendments of substance and form identically, and Attorney Miller had testified during a hearing on Shaw's petition that he was unaware of any authority that would have supported a challenge to the amended information. Under these circumstances, the court reasoned the trial court correctly found that Miller's performance was not deficient. Unfortunately, no transcript of Miller's testimony was included in the record, and so we do not know whether he even familiarized himself with the objection that trial counsel had made, or if he indicated awareness of Hark. According to one of Shaw's state court filings, Miller testified that he could not recall whether he had considered raising the issue, or even whether he had realized that the charging information had been amended. Touching on the issue of prejudice, the state court said only that appellate counsel would not have been able to demonstrate prejudice because Shaw had been granted a continuance to prepare for trial. See what federal district court had to say about it. After the Indiana Supreme Court declined to hear Shaw's appeal, he filed his petition under 2254, in which he carries forward his argument that the Indiana Appellate Court unreasonably applied Strickland to his claim of ineffective assistance of appellate counsel. The district court, emphasizing the deference to be given state courts under the AEDPA, asked whether there is any reasonable argument that counsel satisfied Strickland's deferential standard. It concluded that such an argument could be imagined if one were to accept the Indiana Appellate Court's premise that, before Fajardo, the support in Indiana law for the claim that succeeded in that case was so weak that no lawyer was obliged to make the argument on behalf of any client. Under Strickland versus Washington, Attorney Miller's representation of Shaw cannot be found to be constitutionally ineffective unless his performance was deficient, meaning it fell below an objective standard of reasonableness informed by prevailing professional norms, and 2, his deficient performance prejudiced Shaw, meaning that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. In evaluating an attorney's performance, courts must defer to any strategic decision the lawyer made that falls within the wide range of reasonable professional assistance, even if that strategy was ultimately unsuccessful. And because of EDPA, an extra layer of deference enters the picture. We will defer to the Indiana Appellate Court's determination that Shaw received effective assistance of counsel unless that determination is contrary to or an unreasonable application of clearly established Supreme Court precedent, always based on an unreasonable determination of the facts. An application of Supreme Court precedent is reasonable, even if wrong, in our view, so long as fair-minded jurists could disagree over its correctness. The combination of Strickland and Section 2554D requires deference upon deference from federal courts reviewing the constitutionality of state criminal convictions. Before delving into the merits of this case, we must address the state's opening argument that this court is entirely prohibited from evaluating the Indiana Appellate Court's assessment of Shaw's claim because that claim involves a question of state law. As the state correctly observes, federal courts are not permitted to review a state court's resolution of state law questions. Wilson versus Corcoran, 131. Moreover, although claims of ineffective assistance of counsel can be premised on an attorney's failure to raise state law issues, see, federal courts reviewing such claims must defer to state court precedent concerning the questions of state law underlying the defendant's ineffectiveness claim, etc., etc. I think this is important, though, that when Brendan is being represented by Steve Drizzen and Laura Nyrider, they cannot question the conviction of Stephen Avery. Let's just go through that again. As the state correctly observes, federal courts are not permitted to review a state law's resolution of state law questions. I think that's one of the reasons, as I say, why Steve and Laura have really never. I very rarely hear them speak about Stephen's case. When I've been to presentations, it's often a question saved for the end. Are you in contact with Kathleen Zellner? If Stephen Avery was to be released, how would that affect Brendan? They say that they are in touch. They say that obviously they follow what's happening. And yes, as soon as Steve's conviction is vacated, that means then that they are then permitted to review the state court's decisions of state law questions. I think that's the correct interpretation of it. Anyway, let's get back to our case. The state's argument, however, misses the point that Shaw is making. Shaw is not asking, and has no reason to ask, that we second guess an Indiana court on the meaning of 3554. Shaw is making a simpler point. A competent lawyer in Indiana should have recognized that there was a state statute under which relief for his client was possible and would have pursued that theory on appeal. An argument about the validity of the state's effort to amend the indictment would have been materially stronger than the frivolous sufficiency of the evidence point that Miller raised. With that much accepted, there is no further role for the federal judiciary, whether the Indiana Appellate Court would have been persuaded, or if not, whether the Indiana Supreme Court would have granted transfer, is immaterial. The state's argument that even this kind of comparative assessment is out of bounds, if accepted, would foreclose federal review of almost any ineffectiveness claims that rests on an attorney's mishandling of a state law issue, no matter how egregiously deficient the attorney's performance. It is well established that a defense attorney's failure to raise a state law issue can constitute ineffectiveness. The constitutional right to counsel and its derivative right that counsel be at least minimally effective is unrelated to the source, whether the state or federal, of the defendant's defenses. To argue otherwise would be to attempt to resurrect an argument that the Supreme Court implicitly rejected more than half a century ago when it held that the 14th Amendment entitled capital defendants who had, so far as appears, no federal defenses to the assistance of counsel. I think we'll finish off here. Yes, let's finish off here, because that's been quite a while. And we'll carry on with the next part of this case, this, let's say, Shaw versus Wilson case. I say this isn't Hamilton that's writing this, but he's agreeing with it. But as I say, it just struck me as, how egregious does a case need to be to finally be given a writ of habeas corpus, particularly from somebody who is so politically sensitive as Hamilton, who just doesn't want to go against his colleagues, if you like. At least that's my humble interpretation of what's going on. Anyway, as I say, we'll save the next bit for a later date. I don't know if that will be before or after. I'll probably be after the next bit, after we get to speak with Tracy Keogh. One of the problems I am having is that StreamYard only allows you to do 20 hours of streaming per month, and I'm getting close to that limit. So I don't want to risk running out of time with Tracy. So yes, we'll catch you again on Saturday at, I say, 12:30, half past midday UK time, 9:30 in the evening Australia time with Tracy Keogh. And if I can press gang a couple of other people to join the panel, such as the Hard or Dr. Siltman, then I will do my best, as you can rest assured. Okay, thanks very much for tuning in. We'll catch you again soon. Bye for now.